Welcome to Season 3 of Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health. I'm Josh Sharfstein, Vice Dean for Public Health Practice and Community Engagement and a former Secretary of Maryland's Health Department. Our goal is to bring scientific evidence and experience to the public health news of the day through informative interviews with scientists, community leaders, policy experts, public health officials, clinicians, and more. If you have ideas or questions for us to cover, please email us at publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Today, our topic is the recent mass shooting in Indianapolis and what it means for the national discussion of so-called red flag laws. In March 2020, the suspect's mother called the police out of concern for his safety, and the police took away his shotgun. However, just a few months later, the suspect was able to purchase additional firearms that he used in the shooting. Indiana has a so-called red flag law that allows a court to prohibit gun purchase for people in crisis. So what happened? I speak with two experts on these laws, Josh Horwitz of the Coalition to Stop Gun Violence and Shannon Federoli of the Johns Hopkins Bloomberg School of Public Health. Let's listen. Josh Horwitz and Shannon Federoli, thank you so much for joining me on the podcast to talk about something that's in the news, which is this horrible mass shooting in Indianapolis, and the fact that while the alleged perpetrator had his gun taken away, he was then able to get more guns. And this is being discussed in the context of Indiana's so-called red flag law. So maybe I'll start with you, Josh. Could you explain what this focus on this Indiana law is about?
Sure. So Indiana has, as you called, a so-called red flag law. I prefer the extreme risk protection order or extreme risk laws, but Indiana does have one that allows for firearm removal by law enforcement and then a court proceeding to see if the firearm should stay removed and whether the person should be enjoined or prohibited from getting firearms in the future. What we see in Indiana is that law was actually not used. So a firearm was removed, but the process was never started. So what that means is the law was not invoked, therefore there was no prohibition moving forward. Indiana is very unique in that way. In fact, it's the only state where you remove a gun and then you start process later. All the other states, you start the process first, which is very important for due process, but also because once the court's involved, they can put the flag in the prohibition so that someone can't buy a gun going forward.
I see. So there's been some reporting about what happened, that it was a failure of the law. In this case, though, it sounds like you're saying the law was never really triggered in a way.
Exactly. The law was never used. There was a decision by the prosecuting attorney not to go forward with the Indiana's extreme risk protection order process. The process was available but not used. So it's not a failure of the law. The law was never used.
And had they used the law, what would have happened differently?
If they could show that the respondent, in this case the shooter, was a danger to self or others, and there's a number of criteria there, the gun would have been removed for 180 days, and you would not have been able to purchase a firearm for 180 days, and that order would have been renewable as well.
I see. So this situation may lead people to think about the value of using a law like this.
I hope it does. This is sort of a situation where the law should have been used. The law in Indiana has been used at times for this situation. And it's actually why the law was designed, because there was a tragedy over a decade ago in Indiana where law enforcement had to give firearms back, and then the person went on to shoot another law enforcement officer. So it mirrors that. And now they have the law, except they didn't use it. So we've seen a lot of headlines saying the law didn't work. It can't work if it's not used.
So let me turn to you, Dr. Federoli. Can you help us take a step back and say, what are these laws? What do they say? And how important is the implementation?
Yeah, thanks, Josh. So these laws, as Josh mentioned, we like to call them extreme risk protection order laws, are a really important tool for families, for law enforcement, for healthcare providers when they see someone who's in crisis has a risk of harm to either themselves or other people. And they need a measure to temporarily and legally intervene to make sure that they don't have access to guns and access to guns that they already possess. But we also want to make sure, and extreme risk protection orders do this, that they can't purchase new guns. So extreme risk laws are based on domestic violence protection order laws, something that's been in place in all 50 states for decades now, and are a critical part of how families and law enforcement respond when loved ones are violent. Extreme risk protection orders are another way of applying that model. But as Josh said, in order for them to make a difference, they need to be used. They need to be implemented. And really, it's one of the reasons why we've dedicated a lot of our resources to focusing on implementation of these laws.
So how many states have these laws?
Right now, we have 19 states and the District of Columbia that have extreme risk protection order laws in place.
And they're not all exactly the same, it sounds like.
There's variation among them, but the general idea that they recognize that there are times in people's lives when they're in crisis, and a gun just isn't a good idea, makes a lot of sense. So having a mechanism to temporarily remove guns from the equation when someone is behaving dangerously and at risk of violence is something that's just a good idea, and is the basic premise behind all 19 of those laws and the law that exists in the district.
And these states that have passed them, they're from across the board politically, is that right?
There's tremendous variation. This is a type of law that we've seen just resonates with people. It resonates with people in red states and blue states and purple states. It resonates with gun owners. It resonates with Republicans and Democrats, which is terrific. It, I think, really reflects the common sense nature of this law. If people are in crisis, if they're expressing, if they're showing signs that they're going to be violent, I think we can all agree that they shouldn't have ready access to guns.
So when you say that implementation issues are important, what are the top ones in your mind?
So we need to make sure that the people who are on the front lines of witnessing people in crisis, so family members, law enforcement, clinicians, know about these laws and know how to initiate them. We need to make sure that the laws themselves are written in a way that is accessible to people who can initiate these laws. So one of the things that I've seen in news reports coming out of Indiana is that there was uncertainty on the part of law enforcement as to whether or not the behaviors exhibited by the individual would have met the criteria for getting an extreme risk order. We need to make sure those criteria are clear and known and appropriate to allow for early intervention when people are in crises. And we also need to make sure that the infrastructure, that the systems that are going to support the hearings, the gun dispossession that takes place are supported and resourced, and the people who are involved in those systems, judges and court commissioners and law enforcement, are trained and resourced and understand the value of these laws and when they should be applied.
Got it. So, Josh, I want to go back to you. It sounds like it's not only important for states to have a well-written law with the process very clear so there's no confusion, but also there's a lot of attention paid to implementation. What are the prospects for the strengthening of these laws and their implementation in 2021?
Well, there's a couple ways to think about that. So the Biden administration has made it a priority within their firearms package to have the Department of Justice work on model policies and procedures and laws for the states, which is great. What we really want to see is follow up with resources. And I think there's a number of ways that can happen. And we're urging the administration to put money into the budget and other areas to support extreme risk protection order implementation by the states, as well as to help incentivize other states. One of the things that we're also would like to see the administration support, and we are very supportive, is a bill from Representative Carbajal and Senator Feinstein, which would provide money for the states for training and implementation practices. And we're very supportive of that bill. And I think the bottom line is the way what Shannon was describing is a comprehensive system, which really needs funding to make it work and to get implemented well. And so the piece that I think we need to get across is that for federal appropriators, for federal legislators, and for the same counterparts in the states, if they want to avert the types of tragedy we saw in Indiana, and we want to stop some of the suicides that we see on a daily basis and other daily gun violence, investing in extreme risk protection order implementation is extremely important.
I was just going to add that the good news here is that we have models as to how to make this work. So there are localities in different parts of the country who have put the infrastructures in place that Josh is talking about and have great systems that we can look to model how to do this well. So there's no need to reinvent the wheel here. We have local jurisdictions that are implementing extreme risk protection order laws quite well that we can look to and learn from and replicate across the country.
Got it. So it sounds like, as far as Indiana, what you were saying is there may be a need to revisit the law to bring it more in line with other laws like this, so that at the time, if someone really needs to lose access to their guns, they also shouldn't be able to go right back out and buy guns the next day. But at the same time, really have resources for training people so that they really know about the appropriate use of these laws, and there's a system that can implement them effectively. Is that one of the bottom lines here?
Yeah. My suggestion for Indiana is to update their law to bring it into the recommendations that we've made collectively as a group that both Shannon and I participate in, called the Consortium for Risk-Based Firearm Policy. We have a set of recommendations. We believe that Indiana should follow those recommendations, including starting the process with a court procedure, both for due process protections and to make sure that that record is entered into the appropriate background check system. Second, clearly, there's only one jurisdiction in Indiana that uses extreme risk protection orders on a regular basis. Indiana has one of the oldest laws, but somehow doesn't use it enough. And there's lots of firearm suicides in Indiana as well. We could do better prevention with better training, and that's going to take some resources. And I urge the state of Indiana to find those resources.
Great. Well, Josh Horwitz, Shannon Federoli, thanks so much for joining me on this timely and important issue.
Thanks for having us.
Yeah, thank you, Josh. Great conversation.
Public Health on Call is produced by Josh Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmond. Audio production by Spencer Greer, Niall Owen McCusker, C.N. Oates, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo and Neiman Outland. Social media support from Brenda Haggader, Grace Holes Fernandez, and Caroline Wong. Thank you for listening.